guys. I think we are live right now for another monthly edition of Alabama Work Comp Today. And we want to welcome our friend Sarah Stottlemyer from Atlanta. Hey, Sarah, how's your day going today?
Hi, just every day's great. Thank you for asking.
Well, we appreciate you spending some time with us today. As we do each month, we try to just cover issues that are throughout the country that are hot topics that deal with employment, work comp, and related topics. And as we've done for the last 4 or 5 months, is we'll talk about some of the topics we've previously talked about, then we'll go into some of the national news, and then at the end we'll talk about some Alabama cases and laws, and we'll compare them with your state in Georgia. But before we get into all of that, if you would, Sarah, tell us a little bit about yourself and your practice, please.
So you've already introduced me as Sarah Stottlemyer. I've had my own firm in Atlanta, right in Buckhead, since about 2012 or so. I've been practicing workers' comp since '07. So it's been about 13 years. I spent the first few years doing insurance defense, like many claimants attorneys do. And then I switched over to represent those who needed help being ushered through the system. And my practice has 3 other attorneys besides myself. We've got another one joining in April or so. And then we also do about 35 to 40% personal injury work, but I only do workers' comp.
And workers' comp is so different in Georgia compared to Alabama. Heck, Alabama is so different from everybody else. That's one of the things that I really am glad that you've joined us today. And Dave, you can talk anytime now, so please chime in.
Y'all are doing great.
That we want to compare a little bit as we go along how Georgia law differs from Alabama's antiquated system that we have here. But before we get into that, Sarah, I want to pick up, Dave, where we were last month a little bit. We've had a couple of different topics that have been ongoing for us this whole 5 or 6 months that we've been doing this. And most recently, and I hope you had a chance, Sarah, to kind of look at this a little bit, that Delta has had such a nightmare with the uniforms that their employees are required to wear. And they brought one or multiple lawsuits. It's 100,000 employees here. But Dave, the headline is Delta to replace uniforms.
Yeah.
And what did you glean from that?
Yeah, so Delta used Lands End to design and provide uniforms for not only their flight attendants, but their airport agents, mechanics, fleet service agents.
The very cute purple ones, right?
That's right. And there were lawsuits brought by the employees against Lands End because the employees were suffering from skin rashes and other allergic reactions from wearing the clothing. And so fast forward, they're dropping that uniform design and coming up with a new one.
But are they going to go through Lands End for manufacturing again?
I wouldn't think
it doesn't appear to be. You know, they're not unionized, but they're trying to get organized, and I think they're trying to use this situation to help show that the air attendants, and it's not just the flight attendants, but I think it's all different Delta employees, regardless of what they do, don't have some of the powers that a union might have. I just found it to be a very interesting circumstances and a complete nightmare for Delta.
Well, the outfits are very cute. Being in Delta's hub in Atlanta, whenever they introduced the outfits, I was like, everyone's going purple. That's very cute. But I mean, you've got to also have other concerns about Lands End does a lot of private school and school uniform clothing. And I mean, I don't think that that's been an issue, or at least I haven't read anything of it being an issue in those instances. So I wonder if they got a bad batch.
Right. Well, it's costing millions of dollars and huge contracts, but I guess this will continue to play out over the next however many months or a couple of years. But it's a huge, one of the biggest employers in the country. And it's amazing how this one issue affects so many people and the downstream effects that it has. But anyway, I'm sure we'll continue to keep watching what's going on there. So let's move on down. Another topic that I think we've addressed in every show is dealing some aspect with the gig economy. And most recently, there were articles that talk about how these companies are trying to carve out the exceptions for themselves, these huge companies, and the only people who ended up suffering are the people who are working for these different companies. And Sarah, I know that you know gig economy workers can be many different types. Probably in downtown Atlanta, you have courier services. You certainly have Uber. You probably have all different types of delivery, part-time food delivery. But what do you, Dave? What do you take from this, the gig economy, this misclassification, and they're trying to campaign to change things?
Yeah, they just keep getting themselves in more trouble. Sometimes they're trying to make law and say what an independent contractor is or is not, and you keep inviting more lawsuits and they're misclassifying these workers and creating more issues. And you're right, we've been covering this for several months now in these monthly sessions, and I think we'll continue to do so as well, because it's just an issue that's not going to go away anytime soon.
Sarah, do you ever deal with any injured workers who are Uber or any of these gig type jobs? Do you ever
We haven't really yet. I mean, like on the PI side, sometimes we do, dealing with like Uber drivers, and we always, recommend that they immediately file more along those sides. But I mean, I know with Willig, which we're all three members of and serve on the executive committee and board, that, they're kind of taking up the national fight on these things to prevent a large group of our workers from being classified as independent contractors and thereby not entitled to any sort of workers' compensation benefits if they get injured on the job. So I think that it's just an evolving area of the law, and it'll continue to be.
One of the things that I really found interesting in this article is it said that the only about 1% of the entire United States workforce are considered gig economy or gig situations. But they are sure the companies that deal with that are really putting millions upon millions of dollars behind this to try to change the law to protect themselves. And some of the other areas that they mentioned in this article was the transportation industry, home care industry, logistics, and technology were some of the most, I guess, affected areas. But again, much like the Delta situation, and maybe even much more so because there's so many more in this gig economy case, this is going to go on for quite a while.
I think we all three use Uber and Lyft and benefit from those services, but I want those drivers covered with workers' compensation, have the option of health insurance and unemployment compensation. We want more people covered with those type of employee benefits.
And just step aside for a second. Yours truly finally figured out some of the logistics. So those of you watching live on YouTube, you now can make comments and I'll be able to see them, and we'll be able to harass you or at least publicly comment something there. But let's kind of move on a little bit, and we're going to shift gears now to the area. Let's see, what was next on our list here?
Fair pay to play.
Thank you. That's exactly right. This is, I'm going to call this, and this is not unique to me, this is the TUA-inspired bill. There are many states around the country, California taking the lead, who came up and passed this law earlier, last 6 months or so. And it's now finally been introduced in Alabama. I don't know if there's one in Georgia. I wouldn't be surprised at all if there is. But at least a dozen other states have proposed laws in the pipeline for their respective states. And it's in the House of Representatives, I think right now, Dave, it was proposed to help with the name, image, and likeness of college athletes. And more specifically, what this law is proposing is for the schools to create, the universities that offer on the collegiate level, to create an athletic injury and wages fund from the revenues that are generated in the athletics department. And ultimately, it's for career-ending injuries, long-term injuries, and if there's money left over, I think at the end of each school term, to be revenues to be divided in some way. And I didn't get too deep into how that's supposed to happen, but these revenues are supposed to be divided amongst the scholar athletes, student athletes, excuse me. Dave, what any other take on this?
This the California bill was signed into law last September, and a month after that, the NCAA voted unanimously to allow athletes to be compensated, and they're working out the specifics of how that will come into play. But I think the NCAA felt the pressure from California passing that law, and several other states are looking at similar laws to what California proposed, or what California signed into law, as well as, like I said, Alabama is considering.
Well, if you remember, and Sarah, we actually will give you a chance to speak in just a second.
Oh, I'm listening. You're good.
The NCAA's proposed changes are supposed to take place the California law is 2023. The Alabama law also says in 2023. And I think what this is a continual putting the pressure on the NCAA. Hey, it's time to come into the modern times for these athletes who do so much and bring so much revenue generated to the schools. You can argue it either way. Other side say, well, you get a free scholarship and you get all of these benefits. That's, to me, and having been a scholarship athlete, but we were fortunate enough when I was going through undergraduate at Vanderbilt playing football, our family was able, my dad and mom were able to provide me with some necessities every month, a little bit of an allowance, if you will. It wasn't much, but I didn't need much. But the way the NCAA is set up, if you're on full scholarship, you can't have a job during the school term, particularly in the semester or the time period when you're playing, because Lord knows you're working 30, 40, 50, 60 hours a week at what you're at school for between academics and athletics. It's time to come into the modern times with this. And Sarah, I don't know if you see any of this in Georgia or have had any experience dealing with it.
So I have no idea whether or not they've passed any laws in Georgia. I don't think they had, because I would have probably heard about it. My husband and I actually differ on this issue because he feels very, very much like you in the sense that if they're benefiting financially from the likeness and the sports and all those things that college athlete brings to the school, then the college athlete should get a piece of that or a cut of that. It's very slippery slope because I feel that going to school at Chapel Hill, we had fantastic basketball players and football players, and they are given a lot of benefits for being college athletes, plus, Carolina education. They get an academic center. They have their own cafeteria. They get card leases for $0.01 a month. There's all kinds of things that go on that I think that they're reaping a lot of benefits. If they don't want to do that and they don't want to use the school resources that they're given to improve their sport, then they could go pro if they wanted to right out of high school. So I differ than my husband on that. But granted, I'm not a college athlete. I had a lot of really great friends that were, and yeah, they work 40 hours a week training and doing all those things. And it's insane. I am fully in favor, though, of some sort of fund that could protect them against severe injury, or career-ending injuries that would provide them with coverage. I think that would be a huge benefit and very deserved.
Agreed. You got anything else to add on that? Again, this is a yet another topic that there's no finality to it. It's going to be a reoccurring theme that we'll come back to, just because it's very similar from a work comp setting. When you've got these college athletes who get hurt on the job, what protections do they have?
Right.
But I
think they absolutely deserve those protections. 100%.
Absolutely. Well, let's kind of shift gears now. Let's move on to some current topics that are around the country. And the first one is out of the state of Texas. Dave, I'm gonna let you take the lead on this one.
Okay. So this is our first time, I think, talking about strippers or exotic dancers on the show.
Few models.
And we're going to give you plenty of time to discuss. I know there's several clubs in Atlanta, and you may have represented some of these women.
I've never been to any of them.
You've never been to any of them, but if you represent, okay.
Yes.
All right. So here's the story out of Texas. A stripper falls off a 15-foot pole, breaks her jaw, and keeps twerking. Working and twerking is what the article says. Smashed her jaw, shattered her teeth. And one of the interesting things about this was that I was, as a work comp lawyer, was wanting to know is whether she has workers' compensation benefits.
Is she an independent contractor?
Independent contractor or employee. And interestingly enough, she created a GoFundMe page to help pay her medical expenses, and the fund had raised about $20,000. And she had to have surgery on her jaw.
That may answer whether she has health insurance or not. Admittedly, I don't know enough about the adult entertainment industry to know if there's any protections or if you're in a union. And I don't mean to make light of what happened to this woman, because I saw the video that's been posted everywhere. It's horrible.
It's horrendous.
It really is terrible. And not to make light of this, but frankly, this is very similar. What about somebody who falls off a roof or out of a tree? And we're going to get some of those scenarios.
Yeah.
15 feet on a hard surface, she's lucky to be alive.
Yeah.
Now, I know if this were a situation where it was outdoors and it was a tree or a house, and there was a fall like this, if it was a death, OSHA's going to investigate. But a single person incident like this, I don't know if OSHA necessarily gets involved. I think you have to have 3 or more injuries and or death, at least one death. But I don't know how you change anything. I don't know if there's union here to protect her whatsoever. I looked for other articles. I saw nothing that dealt with this beyond the quick article about what happened.
Well, I mean, if you're on a pole, I don't think there's really a lot you can change with a pole. That's kind of standard for most of these establishments.
There's no safety harness.
There's definitely, I mean, there could be a harness, but it's probably not a safety harness.
Good point.
Could be hanging from the ceiling. You don't know. There's all kinds of things that go on in these clubs. But I don't think that OSHA would be involved in it. And I think that she's kind of SOL probably when it comes to workers' comp benefits, unfortunately.
And I saw on one satirical website that maybe she should have been wearing a helmet. That might have helped.
Could have been part of her costume.
Well, we certainly, even though we're making light of this, we certainly hope that she makes a recovery, and there's some things done in the future where nothing like this happens again, because frankly, she could have snapped her neck and could have been dead.
I mean, 15 feet, that's a really tall pole, right?
It's probably a 2-level club, maybe, with one of the poles in the middle. I don't know.
All right, you two, let's move on to Oklahoma. This is, of all the topics that we're really talking about this week, this is the one that really gets my interest, and I'm very happy that this bill was passed in Ohio, because we don't have this in Alabama. I don't know if it's been passed in Georgia, but the first responders PTSD bill has finally been passed in their state, that even if there's no physical injury, the fact that they have the mental condition of PTSD, post-traumatic stress disorder, which first responders, as you guys know, that could be police, paramedic, fire, anybody who puts their life on the line to protect and save others, they're going to get covered finally under work comp. I know Florida passed it last year. Some other states are considering it. Alabama, no way.
A bill was dropped this session, a very similar bill. I don't know that it's been debated yet, but there is a bill.
Well, historically, we have not. What about in Georgia, Sarah?
Georgia's been the same. Historically, you have to have a physical injury to get PTSD. We've got a lot of clients that I have to explain this to when they're having a hard time and they're very nervous about certain things that may have caused their, injury, of like climbing up on a ladder or something. I mean, unless they legitimately suffer, I have to tell them something that's almost like a warlike scenario, you're not going to get approved under Georgia workers' comp for PTSD. You know, which I think it's fantastic that Ohio's done this, because I mean, I've got a client that was a MARTA bus driver that was driving, and a guy did suicide by bus, you know, where he drove his car full speed into her, no seatbelt, through the windshield right in front of her. Luckily, she got psych taken care of, but she also had other physical injuries. Had she not had any physical injuries, chances of that happening and her actually getting treatment for it under workers' comp are slim to none. So Georgia's not real progressive in these matters at all.
And unfortunately, there's way too many cases on the books similar to that, similar to where firefighters go into a fire and they're seeing either the people in the fire who they can't save or
Right.
their coworkers. The other first responders don't make it for whatever happens in the blaze itself. And there's just way too many cases. And it's hopefully now that Ohio has this, other states will use it as a platform.
So this bill in Ohio passed the Ohio House.
Mhm.
All right,
Mhm.
it has to go to the Ohio Senate for consideration. So it's not signed into law yet.
Pass.
But it's a big first step in the right direction, and
It's a huge first step.
I hope
Well,
more
hopefully other states will follow suit, because I mean, that's
After it hopefully gets passed, we'll get one of our buddies in Ohio to come on and talk about that.
Yeah.
We'll get somebody from Florida next or soon to also talk about what their experience has been. All right, guys, let's shift to the state of Oklahoma. And this one happened, it's the city of Tulsa. The headline is one contractor dies after a tree falls during removal and another is injured. And this just happened, I think, fairly recently, about a month ago, beginning of the month.
Mhm.
And Sarah, we like you in Georgia are so heavy in pine trees and other trees that frequently are felled for the lumber. This happens way too frequently in our state.
all the time.
And Dave and I have handled many cases over the years.
Yeah.
What's your experience telling you about this in Georgia?
I mean, we have too. The problem that I most run into that really ends up hurting a lot of these people that are injured during that process is that they're independent contractors. A lot of time it looks in this case like he was just a subcontractor for the city of Tulsa, but a lot of times they're independent contractors, you know, that are just coming in and doing tree work. And then they get injured. And again, then they don't get workers' comp because they're not full-time employees. So that's what I've run into. I had a case one time with a guy whose employer had, I think, 3 employees, which is the minimum for Georgia to have, you're required to have workers' comp in Georgia if you have 3 or more employees. Anyway, he had a tree fall on him, broke his back, and he was doing some work like cutting the tree down at his boss's house, you know. So we filed for comp. The guy didn't have any insurance, so we filed it with the fraud unit, and it came back. The fraud unit's like, well, we don't think he really had to have it. So I mean, literally the guy he ended up screwed, you know. And it's absolutely terrible that these things happen because he was technically an independent contractor, even though he was there every single day and worked for the same employer for a year. I mean, he could still go out and work for other employers. He had a lot of his own tools. So, I mean, it just gets very tricky. And a lot of times on the losing end is the injured worker.
Sarah, did your client in that scenario, did he have health insurance or any other protections?
Nope.
And he was probably looking at 50 or 50,000 or
I mean, I think he had like $120,000 hospital bill. Like, it was bad. He had to have a surgery and stay overnight for like 10 days or so. I mean, it was terrible. No health insurance. He was an undocumented worker. So it just, yeah, I think he ended up, you know.
Worst calls that I have to deal with is seriously injured workers, catastrophic injuries, $100,000 plus medical bills, surgery. And they're independent. They think they're invincible. So they're not worried about work comp.
Right.
Don't think about the consequences of not being covered. And there's just no coverage. There's no way to to get them compensated.
There's no, I mean, there at that point, there's nobody to go after. I mean, we even looked into a third-party claim of going after the home insurance of his boss, since it was then on the property, and he didn't have. I mean, it just was a disaster. I don't think he had insurance. You know, I mean, there's just no way to collect on any of it. It was awful.
Frankly, the only other potential avenue at that point is going to be Social Security disability.
Unless they're undocumented.
No.
So it just, you know, you really have to get some sort of coverage to protect yourself in situations like that. Even if you are an independent contractor, you need to get short-term disability or and health insurance, at least catastrophic health insurance.
We've got a set of laws here called Employer Liability Act.
Mm-hmm.
A lot of times, if work comp doesn't apply, if straight negligence doesn't apply, there's a set of laws that we can pursue against an employer. But the trade-off here, unlike our no-fault work comp laws, is all the defenses that aren't available under our work comp laws then become usable against our employees.
Contributory negligence and assumption of the risk and all those things.
Okay. That's right. And sometimes we'll plead when we don't know the true legal theory that's ultimately going to play out. We may plead them in the alternative in the same lawsuit.
Mm-hmm.
Does Georgia have any similar laws that are alternative?
Not that I know of, no.
Yeah, I don't know how unique that is to just Alabama, but it's been an alternative theory we've been able to use a few times over the years.
Right.
All right, guys, anything else from the Oklahoma case to shed light on? No?
Moving on to another tragic story.
Yeah, I'm sorry that
Georgia.
Every one of these headline stories each month that we bring up around the country never have good results. They wouldn't be in the news otherwise. Yeah. But now we're gonna come to your home state with a trench collapse case. So Sarah, tell us a little bit about that case.
So it looks like a guy was digging a trench in one of the gas stations and it ended up collapsing. I think 3 of them ended up getting out. There was one guy up to his waist, one guy up to his ankles, and unfortunately, and I think another one in there, and then one just went completely under. And when that happens, you suffocate. So he ended up dying in the trench collapse, which happens all the time with these workers that are working for the city and in, sewage pipelines. I mean, my husband owns a landscaping company and they'll be down in there digging up, around a water main or something or pipe, going to a house, trying to make sure that they don't hit that with a backhoe when they're doing resurfacing. And, you get into those deep trenches, it's not safe. And it's.
Yeah, well, I don't know in this case if a trench box was required. I did see that they may have, the initial investigation is they may have been digging deeper than what was initially supposed to be, but I'm sure that's quite common that they may not, until they get into the earth, they don't know really what they've got. But we've handled some trench box or trench cave-in cases where the box was not used. And sometimes that's because of scheduling or deadlines or cutting corners.
Mm-hmm.
Again, none of these cases have good outcomes.
No.
Well, it seems like some of these can be avoided by using a trench box and by putting the pile of dirt more than 2 feet away from the hole. And I don't know. We don't know the details of whether that was done properly or not, but it is sad to see.
It's Sarah I don't know what the ultimate outcome of this case will be. If I'm sure there'll be lawsuits, because it looks like 3 were trapped and there was obviously the one death. Mm-hmm. But if this case were brought in Alabama, assuming it's just against the employer, we've got a case for wrongful death, work comp proceeds. Mm-hmm. And then depending on the injuries, we've got 3 just personal injury, work comp case. I don't mean personal injury, but work comp claims. but I don't know if the article shed light if there were other entities also being blamed for this, or if it's just the employer.
I don't know. It didn't seem like it did. So the one guy that died was from Dalton, Georgia. So I think there was just, so I'm assuming it was Durham, North Carolina that was in the trench, and maybe he was suing there. So then you've got to compare the two benefits on, where the accident happened, where the contract was made, choice of law issues on which comp side you're going to want to proceed with. But I don't know that there would be anybody else besides the employer really to go after, unless, maybe the property was aware of unsafe conditions or, things that could cause that. I have no idea.
This is one of those unfortunate and tragic cases where a lot of investigation to figure out who's ultimately the blame.
Right.
This, and again, it could bear out that there's multiple parties here. But anyway, let's pivot on to the next one. Next one's out of California, and boy, this judge was just so mad at this company. Dave, you want to take the lead on this one?
It's hysterical. Yeah.
So DoorDash, and that's another company that's in the gig economy, like we talked about before, and DoorDash made or required its drivers to sign away their right to sue if there was a legal dispute that arose between DoorDash and the driver. They made them, or they required the drivers to arbitrate any claims they had against DoorDash. And arbitration it's an expensive process. It takes the case out of the court system and makes it a private arbitration, which usually favors the employer over the employee. So interesting part of this case was Judge William Alsop required DoorDash to arbitrate over 5,000 individual disputes with their drivers who claimed they were misclassified as independent contractors, going back to what we talked about earlier with misclassification. And the judge was also going to require DoorDash to pay a $1,900 fee for each of the individual arbitration proceedings, which is about $10 million. So the judge was just fed up with employers, large companies, making their employees, their workers sign away their rights. And he put a stop to it in this particular case.
Oh, it was brilliant. I mean, that's going to make DoorDash settle these things a lot faster than dragging it out. I thought it was a fantastic move.
I wonder if this company has insurance that covers this or not.
You better hope so.
Maybe some lawyers getting in trouble or have gotten in trouble for whatever they advised their company they were working for.
Well, the hysterical part, I think, too, is didn't it say that like they signed away their ability to be a class action? So they double screwed themselves, because had they been able to do that, then they could certify them as a class action. But since they did that, they're like, well, sorry, every single one of you, $1,900.
That's right. Boy, this judge came off the top rope and just brought the hammer down.
Oh my God, it was amazing. Yeah.
Sarah, let's stay on arbitration for just a minute. Is that an issue for you in Georgia with work comp cases?
No, not in work comp cases. No, we don't have any issues with that.
Well, thankfully, we don't either, but I know that it rears its ugly head every few years when they're trying to propose new laws. I know that doesn't get swept under the rug very quickly. Dave, I know you deal with that a lot more on the front lines than I do. Has that been a current issue of sorts lately?
No, I don't. Not as far as any proposed legislation. I think there may be a case or two floating around in our appellate court system right now about arbitrating some employment-related matters, maybe even a work comp in there, but I don't know. I haven't seen any recent appellate decisions on it.
Well, let's just hope it never rears its ugly head anymore. But it was about 25 years ago. They tried to get it with tort reform in Alabama, and it never took hold, thankfully. But anywho, all right, let's move on to our last national case for this session that we're talking about. Unfortunately, this is up in Milwaukee, up in Wisconsin, and a tragic situation where a mass shooting and suicide occurred at a beer plant. And I don't necessarily know if it even matters the motive why this happened. But this fellow was an active employee at the time and took out a bunch of coworkers. And it's just another issue that has come back to the light in our national news, and it's just sad. And it just shows there's so many issues here to unpack. Sarah, if this were in Georgia, what type of issues are you looking at as potential claims?
So I think some of the issues, so what was it? I think it was 5 people that were killed, right?
Yeah.
So you'd obviously have survivor benefits. You know, I don't know whether or not they have the PTSD thing, because if you do, and you've got people that are seeing their coworkers be killed in front of them, you know, in Georgia, we've got an issue where sometimes it's a defense where if the injury was caused by something that was personal in nature, but not the work itself that caused the injury. So, you know, if say the guy came in and shot another guy because he was having an affair with his wife, right? Then it might not be a compensable claim. So I think we're going to just have to get into the motive of it and just kind of unpack it from there. I mean, it's a horrible tragedy, and it happens all over the country every day now. But I think that there's definitely a lot of things to look at, and how many people were in the building and how many people are going to be affected by it. It's just awful.
Yeah, we're very similar in Alabama. You're right. It's about what the intent or motive is. If it's work related, then it will be covered under work comp, whether they're survivor benefits or whether someone was shot and injured, then they'll get covered under work comp. But as you said, if it's personal in nature, if he owed him money, or if it was an affair in between their spouses or something like that, and that's probably not going to be covered under work comp.
Right.
What about this scenario? And yes, we're playing with the hypothetical facts here. What if the company knew this fella had issues in the past and still hired him? Could claims be brought for an unsafe work practice, or work, not practice, but unsafe work environment? It's extremely tough to hold other entities responsible for the third-party criminal acts of another. I'm sure Georgia is very similar to Alabama in that regard. But just for these facts, Dave, Sarah, how do you think this plays out if the company did a background check and still hired this guy, even though they saw X and Y and Z that frankly might have or should have tipped him off that he had some issues?
Right. I mean, I have no idea how that would play out. And unfortunately, I lost you about like halfway through. My internet was doing something a little bit weird. But as far as if HR ignored a bunch of red flags, I think that you're going to have a much more expensive case on their hands than just under workers' comp, you know, that you can actually proceed with like a negligent security type case. And as I always tell my clients, it's very beneficial to always have a different case besides workers' comp, because we all know, unfortunately, they do not pay a lot of money for injured workers. So if there's a deeper pocket that you can go after, I mean, I don't know about the specifics of this guy and whether or not there were red flags in his background, but if there are, it's definitely a claim that an attorney would probably want to take a look at pursuing.
Dave, anything further to add?
You know, as far as Alabama, you got to start with the fact that if you're looking at a claim against the employer for anything other than the work comp, you got to start with the fact that the Work Comp Act is a defense to any other type of case against the employer. Mm-hmm. It takes some creative lawyering to go after the employer.
Very creative lawyering.
Yeah.
All right, we're trucking along here and moving quite quick. We've got we're getting away from our cases around the country. We're going to talk about a couple of Alabama laws or cases. We're going to compare them with what you deal with, Sarah. And what I'm about to bring up, I want you both to know I'm not calling either of you idiots, okay? What I'm bringing up,
not right now.
Not right now. Off screen, we can chat about that. But I want to bring up a very common thing that we see all the time, and I bet you do too. They're called idiopathic events creating an injury. Dave,
Right.
what's your definition? What do you know to be, what's that idiopathic defense or idiopathic event mean?
I think two of the most common that we see is when the injured worker can't explain how he or she felt, or can't explain what caused the injury. And the other would be something that's personal in nature to the injured worker. All right, so you said idiopathic. Well, that is a defense to work comp claims. So those are the two that I see the most.
Before we go to you, Sarah, David, just give a quick example of one maybe you've reviewed in the recent past, but because of this issue, you weren't able to take the case.
It's like I said, an unexplained trip and fall. Mm-hmm. Unexplained, I turned, I twisted, and my knee buckled. But they weren't doing anything work related. They may be at work, but they may not be doing anything that is a job duty or in the course of their employment, and they just can't explain. There was no substance on the ground. They didn't trip over something. They weren't pushed down by or knocked down by a falling equipment or machine or something to that effect.
Sarah, do you deal with this type of defense?
I do all the time. Luckily, Georgia has just had a great case that came down a little while ago from our Court of Appeals. So in Georgia, it used to be if you trip and fall, say you're at work and you're a teacher and you're walking down the hall and you trip and fall and you blow out your knee, and say you're just tripping over your own feet, right? Unless you hit something on your way down, whether like a cart with stuff in it or hit, even possibly like a big piece of crown molding that was jutting out. If you don't strike something on your way down, then that would typically be considered an idiopathic injury. There's been a long line of cases in the Georgia system that basically say, if it's something that's not specific to your work requirement, if it could just as easily happen outside of work as it does inside, then it would be considered an idiopathic injury. It's not, it wouldn't be arising out of the course and scope of your employment because of the fact that it could have easily happened to you just walking down, outside on the pavement. So we had one case, which is, it was Chaparral Boats here in Georgia, and it was, she was clocking into work. At some point, just walked across the parking lot and she blew out her knee. And they said, hey, that's not going to be covered under workers' comp because of the fact she's just walking across the parking lot to clock into work. However, this new case that just came down basically overrode a bunch of prior case law. And the court's rationale was saying that, if we stick with this type of rationale, then anybody who gets hurt while on the job that could have suffered a similar injury outside of the job or at home, it would never be found compensable. And they thought that was, BS, to put it lightly. So they came through and they said, hey, in Cartersville Schools v. Johnson, this teacher was walking, quote, swiftly kind of around some carts and stuff to get back to the front of her desk and a smart board, and turned quickly, and she ended up hurting her knee, right? Blew out her knee. Well, the administrative law judge, who's our first level in Georgia, says, I find it compensable because it was specific to her job duty to be walking back and forth between, the desk, the smart board, and moving quickly and kind of maneuvering around things, right? So I'm going to find this compensable. The appellate division said, nope, under Chaparral Boats and a couple of the other cases that we've had in a long line of jurisprudence in Georgia, it could have easily happened her walking anywhere at home, right? The exact same thing. She could have been maneuvering around a coffee table. So we think this is an idiopathic injury. Superior Court comes in, which is the next level of appeals in Georgia, and says, no, absolutely not. The appellate division got it wrong. We're, reinstating the administrative law judge's opinion. And then it went up to the Court of Appeals. Court of Appeals finally said, if we continued with this rationale where it could happen anywhere else, but happened to happen at work, then nobody's going to be covered when these things happen at work, short of, again, them striking their head or something when they fall, on something that's specific to their work environment. So they extended benefits, and they basically They didn't overrule all of the jurisprudence, but they finally gave us some clear law in Georgia, which, you know, very much eroded the idiopathic defense of a fall at work, where they would say it could have happened anywhere, not a big deal. So we couldn't be happier about it, obviously, because now it will cover a lot of people that would have been denied coverage. We had some cases in Georgia before that was, you know, a lady blew out her knee because she was bending down to pick up a pill off the floor that was a personal pill. She may have been extraordinarily obese. So, you know, that was idiopathic. I still think that would likely be idiopathic because that has nothing to do with her job duties. However, now if somebody's in their course of their job duties, they will be covered in Georgia, where prior to this Cartersville v. Johnson case, they would not have been. So win for the good guys.
That is, I wish we could borrow some of that good law, but it's a lot of times I know that we have to turn down cases, even if it's great injuries and happened at work. But if our potential new client can't tell us the mechanism, the action, the act that led to their injury, their symptoms, that's a no-go for us.
Oh, it's awful. Yeah. The case law has been really bad for us too for years until this most recent one. And I mean, we were thrilled because finally, you know, a large portion of injured workers in Georgia can actually get medical benefits and income benefits because they were at work when it happened. They were not doing anything personal for themselves when it happened. They were in the course and scope. So we finally got good law.
Good. All right. We got two more comparisons we want to throw out there. And this one is a hotly debated in Alabama. It has been for years because now there's so much money at stake, and that deals with medical care, of course.
Mm-hmm.
The scenario is when our client is not happy, is dissatisfied with the care being given by the authorized treating work comp physician and says, I want a second opinion. And here we call it a panel of 4. And Dave, there's 2 scenarios. Why don't you share with us the 2 scenarios where that pops up that we have rights that we can protect for our clients?
Yeah, so we've got 2 panels of 4. One is if you're dissatisfied with your initial treating physician, you can request a panel of 4 doctors, and you'll get 4 doctors who are in the similar practice area as the doctor you're replacing. The other panel of 4 is called a panel of 4 surgeons. So if the doctor, the authorized doctor, says you need a surgery, then the injured worker can request a panel of 4 surgeons and 4 doctors who are similar in that practice, who are surgeons, will be placed on the panel, and the injured worker can go and discuss that surgery with that new doctor and can stick with that new doctor if he or she chooses.
Who decides who decides the panel?
That comes from the work comp insurance company.
Oh, that's fun. You guys have it great in Alabama.
Yeah.
Yeah, so great. But one of the other things, Sarah, is they have to be the type of doctor who treats this type of conditions. And then even when you choose off of the panel, the doctor still has the right to refuse that patient. And that happens quite a bit, where they then have to replace the panel doctor off of there. So you may be 3 to 4 or 5 months down the road.
Of course.
And it just is so frustrating for.
Well, and what if they're giving you the 4 worst doctors? Like, if you need a shoulder guy, and they're like, man, we're going to give you the 4 worst shoulder guys in Alabama.
They would never do that.
That's insanity. Yeah, that's terrible. I'm sorry you guys are in Alabama. That's all. That's awful. So we don't have that in Georgia. You can have what's called an independent medical evaluation. It's a second opinion that's paid for by the employer insurer with a doctor of your choice, as long as you've received income benefits within 180 days. Okay. If you have not received income benefits, then you have to pay out of pocket to have an IME, which is usually around $1,600, more or less, by the Georgia fee schedule. That being said, you also get a one-time change on the panel of physicians. Panel of physicians in Georgia is what an employer has to maintain. It's got to be properly posted. You've got to explain the purpose of it. You select a doctor off it. There have to be at least 5 physicians on it that you can choose from. So every injured worker, regardless of whether or not you're receiving income benefits, gets to have 1 free change on the panel. Now, as you can imagine, very similarly to Alabama, the panel's not going to be made out of you know, lovely, great injured worker advocate doctors. They are all going to be, you know, they're all hand selected by the insurance company and put on the panel for a reason. Most of the time it's because they return the patient back to full duty, even with, you know, needing a fusion in their back within probably 2 weeks. So they're not always the best doctors, but that's how it is in Georgia. You get a one-time free change on the panel. You get an IME with a second opinion doctor of who you would like to, as long as you've received income benefits within 180 days.
Interesting. Yeah, a little different. It is a little different.
Georgia's better than Alabama. Sorry, guys. I mean, it's not great, but it's better than Alabama.
And you're limiting this to work comp laws, right? We're not going college football or anything like that.
Correct. Oh yeah, I don't have a dog in that fight. Legitimately, pun intended. I went to Chapel Hill.
Well,
We don't have a basketball team this year either, apparently. So I mean, I don't have anything in the fight right now.
well, those off the field or on the field arguments, we can take that up another time. But let's get to our last topic of the day, and that's going to be how cases are adjudicated in our respective states.
Mhm.
We may be the only state that still has a trial by a judge, not jury, but through litigation to adjudicate most of our cases. Now, we can settle cases without having to go to a trial,
Mhm.
but oftentimes, like David and I had a trial 3 weeks ago on a compensability matter where the work comp company of the insurance carrier just stopped paying for his benefits. We had to file suit.
Oh, we have that all the time. Yeah.
Had to go to court. Judge, we just got the order yesterday, 2 days ago, reestablishing his benefits. So it's a good win.
Humble
Great for our
brag.
client.
Humble brag.
Humble brag.
Did
So
you
anyway,
get add-on attorney's fees for that too?
no, 'cause- no, it's a two-step process. This
Okay.
is really the compensability aspect of the case, just to get it back on track.
Right.
We'll then finish the case either through settlement or another trial with this same judge when it's the appropriate time to do that part of it, when he reaches
Okay.
an improvement. But that's not in front of a jury. It's not a panel. It's a circuit court judge, which is also the jury level of judges for us, state court. But it's not through any administrative process. It's strictly through the court system. Discovery, all of the depositions, all of that. How would Georgia handle that kind of a situation?
So we have administrative law judges that are appointed by the state board director, who is appointed by the governor. So we have an entire state board of workers' comp in Georgia. The majority of the judges are former defense attorneys who have decided to stop practicing defense. And so we do all of the normal litigation stuff when it comes to taking depositions of everybody, the adjusters, the employers, the injured workers, sometimes the doctors, sending out all of the discovery documents. And then we go forward with the hearing if we can't get the issues resolved by that time. And then it goes from there for an administrative law judge. They usually have about 60 days to make a decision. They do a decision, then you appeal it up to the appellate division, which has the director and then 2 more appellate judges on it. And you go and you make oral arguments there and you submit briefs. Then you've got 90 days before they make a decision. And then it goes up to the Superior Court, Court of Appeals, and then Supreme Court if they decide to hear the issue and they think it's important enough. But it's normal litigation. It's just not in front of a jury and it's not a circuit court judge.
I think the distinction is when we have a dispute, we go straight to court, to a circuit court judge, whereas y'all go to an administrative body first.
Correct.
Yeah.
And
Yes.
I bet your timing is quicker because we have to file a lawsuit. We have to perfect service. They have to answer the lawsuit. And then it's an additional 60 odd days, usually, maybe 90 or 120 days. So you may be looking at 6 months before we actually.
Yeah, no, that's ours too, unfortunately. So a lot of it's the delay techniques that everybody uses, but it's usually, I tell my clients, hey, if you're getting terribly screwed, it may be 8 months before you get in front of a judge because they're going to want to depose people, You know, a hearing reset is usually 2 to 3 months out. So anytime you get a reset because you haven't gotten your independent medical evaluation opinion, it's another 3 months. So, I mean, I usually say 9 months to a year, and you've got to be prepared for that if you want to go to trial, which, you know, we do a lot, but it's very frustrating for our clients.
Yeah. But guys, this is why we do what we do. This is why we do what we've done for many years, and we'll continue to fight the fight. Sarah, sadly, we've now come to the top of the hour, and we've run through a whole bunch of topics, and we really appreciate you spending some time with us talking through this stuff today.
Thank you for having me. I adore you both.
I hope it has been fairly painless for you.
It has been painless. It has not been bad at all.
Good, good. Guys, we're going to sign off for now. This is our monthly Alabama Work Comp today, where we talk about national issues, Alabama issues. We bring on one of our buddies from different parts of the country who bring their expertise to the table. And Sarah certainly fits that bill today. So thank you again, Sarah. And I think
Thank you for having me.
Thank you for joining us today. Look forward to seeing you next month.
Absolutely. In New Orleans.
Very good, guys. We'll sign off for now. Take care. See you next month.